What is the 2-year minimum period rule? By virtue of Section 30 of the Matrimonial Causes Act, you are not permitted to bring a petition for the dissolution of your marriage within 2 years of the celebration of that marriage without first obtaining the leave of the Honorable Court. In essence, what this means is that generally, your marriage will have to be at least 2 years before you can thereafter bring a divorce proceedings for the determination or dissolution of that particular marriage. In practical terms, what this means is that if you unfortunately get entangled with an idiot in a marriage under the Act, the law expects you to work out your differences, make attempts to work out your differences for at least 2 years with your idiot uh, before then coming to court to have the marriage dissolved. When you bring your divorce proceedings within the 2 year of celebration of your marriage, that divorce petition would be struck out. However, if you want to bring the divorce proceedings within that 2 year rule, you are expected to file before the Honorable Court an application seeking leave of the court to bring that proceedings within, even though the 2 year had not lapsed. Um, in trying to bring such an application, you have to bring before the court facts to justify why it will be inhuman or grievous for the courts to insist that you exhaust the 2 year period before bringing the divorce proceedings. You might, for instance, see that it is going to affect the children of the marriage or the child or children of the marriage negatively if you are to wait for the 2 year period to lapse. Where you obtain the leave, you can then bring the application for the dissolution, file a petition for dissolution of the marriage. Until that leave is granted, you have to wait 2 years since the celebration of your marriage before bringing any divorce proceedings before the court. Any divorce proceeding brought before the court without the leave of court and without the 2 year lapsing, that divorce proceedings will be struck out by the Honorable Court. There are, however, instances where you do not need to wait 2 years, neither are you under any obligation to obtain the leave of court before instituting the divorce proceeding within 2 years of its celebration. I shall be discussing those instances in the next video. See you.